Hello, everyone, and welcome to the Jeffrey Epstein Show. I'm your host, Bobbycapucci, and this is Daily Drop number 204. Today, we're going to talk about the 11th Circuit Court of Appeals and the ruling that they made in favor of the government as opposed to in favor of Courtney Wild. So, during that ruling, we know that evidence was only heard by 3 of the judges. And 2 of those judges decided to side with the government as opposed to Courtney Wild. But one of those judges, Judge Hull, had a scathing reply to the decision made by the other 2 judges that were impaneled. Now we're finding out that the actual co-sponsors of the bill that was in question have come out and they have filed amicus briefs in support of Courtney Wild and her case against the government. And those co-sponsors are current Senator Dianne Feinstein, former Senator Kyle, and former Senator Orrin Hatch. And they have come out and they have filed these amicus briefs with the court stating that they believe that as the law was put on the books, it is not being applied correctly. So quickly, what an amicus brief is. Amicus briefs are legal documents that are filed in appellate court cases by non-litigants with a strong interest in the subject matter. The briefs advise the court of relevant additional information or arguments that the court might wish to consider. Now, you can see why this is important, right? You have the people who actually wrote these laws or co-sponsored them coming out and saying that the law is not being applied correctly by the court, and they think that it should have went the other way. So you have to think with these sorts of statements by people who truly understand the law, you would think, if they're co-sponsoring it, that it will weigh heavily with the court and the judge. A well-written amicus brief can have a significant impact on judicial decision-making. Cases are occasionally decided on grounds suggested by an amicus, and decisions may rely on information or factual analysis provided only by an amicus. So that shows you right there how powerful an amicus brief can be. And with the 3 co-sponsors of the Crimes Victims Act coming out and filing an amicus brief on Courtney Wild's behalf, you have to think that when the whole entire court comes back into session and they hear this case, it's going to be a different outcome. So this article we're going to read is from Reason.com. The author is Paul Cassell, and the headline is Jeffrey Epstein survivors receive amicus support in the 11th Circuit. So I told you when this all first happened not to lose faith, right? That these kind of things, they have to wind their way through the court systems. And a lot of times it's, you have to appeal things several times to get it moving in the correct direction. It might be a judge that is rigid one way or the other or whatever it may be. But a lot of times with the judicial system in America especially, you have to appeal several times to get your case heard. And now with the scathing dissent by Judge Hull added to the amicus brief by the 3 co-sponsors of the actual law, we're not talking about people that don't have a vested interest here, folks. We're talking about people who co-signed the law before it actually went on the books. So that is very significant. It is a very significant part of the case here, and it's a very big piece of information for us to get, because what it does is it shows that it's obvious now that the 11th Circuit Court of Appeals is going to have to hear this as a whole panel. Let's jump into the article here and see just what Paul Cassell has to say. Last week I blogged about Courtney Wild, one of Jeffrey Epstein's sex abuse survivors who is seeking rehearing en banc before the 11th Circuit. En banc is just when the whole entire court is impaneled. It's a French word, and it made its way over into our judicial system. Her petition asked the full 11th Circuit to rehear its earlier divided 2-1 ruling rejecting Epstein survivors' appeal challenging a secret non-prosecution agreement giving immunity to Epstein and his co-conspirators, a ruling I previously blogged about here. So make sure you click on the link in the description box and check out Paul Cassell's work. He's done a lot of really good work when it comes to this case, and especially following it from a legal aspect. So I definitely suggest that after you listen to the episode or while you're listening to it, make sure you read the article as well. I think that always adds a little bit more, right? And I always suggest that I think it's always a good idea to read the articles while you're listening or after or, whatever. But make sure you check out the source material because there's always great hyperlinks in there, et cetera, et cetera. The key issue at this point in the long-running litigation is whether the Crime Victims' Rights Act extends any protections to crime victims before the formal filing of federal criminal charges. And that was the big point of contention, right? That's what the two judges hung their hat on pretty much, and that's what swayed their ruling. So it comes down to how that is interpreted by those who are judges. And it was a 2-1 ruling in the federal government's favor the first time, but I have I feel very good about things going forward if it comes before the whole entire court. Like it's definitely trending towards that at this point. Ms. Wild has argued that, for example, the CVRA's right to confer with prosecutors can apply before the filing of an indictment, a position supported by the Fifth Circuit and the District Court in this case, as well as by a law review I co-authored on the subject 6 years ago. Today, Ms. Wild received some significant amicus support for her petition for rehearing en banc. The congressional co-sponsors of the CVRA, Senator Dianne Feinstein and former Senator John Kyle, joined by former Senator Orrin Hatch, filed a brief stating directly that they had drafted the CVRA to provide rights to victims like Miss Wild. That is so significant, folks. It's basically just blowing up the two judges' decision, telling them that they're wrong. They're not applying the law the way it was put down on the books. And I think that that's a big deal, and I really think that moving forward in this portion of the case, it's going to be significant. If anything, the Crime Victims' Rights Act is even more vitally important today than when it was first signed into law. But if permitted to stand, the panel decision will regrettably roll back the clock to the days before the act when victims and their families were ignored, cast aside, and treated as non-participants in a critical event in their lives. 150 Congressional record at 7296, Senator Feinstein. Rehearing en banc is needed to avoid that tragic result. Restore nationwide uniformity on an exceedingly important issue on federal law and vindicate the rights of crime victims across the nation. This is good stuff. To its credit, the panel majority regrets that its decision does nothing to prevent federal prosecutors from negotiating secret plea and non-prosecution agreements without ever notifying or conferring with victims. 955 F.3D 1196 1221 11th Circuit 2020. And I'm guessing that's the court docket or where you can find the rulings or that statement. I'm not too sure about all of this legalese stuff. Like I tell you folks all the time, I am certainly not a lawyer. But respectfully, statutory text, legislative history, and judicial precedent all confirm that this miscarriage of justice is precisely what the act prevents. In passing the act, Congress made the policy decision, which we are bound to enforce, that the victims have a right to inform the plea negotiation process by conferring with prosecutors before a plea agreement is reached. That's from former Senator Kyle, Dianne Feinstein, and Orrin Hatch. That is the statement that they signed off on as an amicus brief to the court, basically lighting it on fire and telling the court and the rest of the judges that are going to hear this case that according to them and the way the law was put on the books, there is no way that this should have occurred. In addition to the support from congressional leaders, Ms. Wild also received support from the National Crime Victims Law Institute, NCVLI, and allied victims organizations. The NCLVI brief explains, so now this is their brief. This case involves a question of exceptional importance, whether the Crime Victims' Rights Act can attach before formal charges are filed. In the nearly 16 years since the CVRA's enactment, the panel decision is the first federal circuit to have held that the rights cannot attach. Think about that, folks. Think about how significant that is. In 16 years since the CVRA was enacted, the panel's decision is the first federal circuit to have held that those rights cannot attach. It's disgusting, and it's a miscarriage of justice, and I don't understand how we have a Harvard judge sitting to hear this, as well as a 90-year-old man. Nothing against them personally. I don't know them personally, and I'm not saying they're bad judges or anything, but optics matter in this case. In a case where it's been nothing but scorn and stacking the deck against the survivors, how can you even approach it like that? The panel decision is directly opposed to the only other federal circuit to have addressed this question. The CVRA's plain language makes clear that it can attach pre-charging a reading that aligns with Congress' intent to correct, not continue, the legacy of poor treatment of crime victims in the criminal process. The panel's contrary decision rests on strained interpretation of the text and is premised on speculation that a contrary construction would produce impracticalities. Policy concerns are, however, best left to Congress. Further, the last 12 years belie the panel's fear of risking a landslide. OP 52, as the dissent correctly observed, since the Fifth Circuit's 2008 decision and the District Court's 2011 decision, there have been no flood of civil suits by victims, no evidence of victims' abuse of their CVRA rights, and no prosecutors' complaints about impairment of their prosecutorial discretion. Given the plain language, the panel's acknowledgement that it is not implausible that the CVRA attaches pre-charge, the clear legislative intent, and the undisputed reality that the victims endured unspeakable horror and were then left in the dark and so it seems affirmatively misled by government lawyers, the panel's assessment that it was constrained to deny the petition strains credulity, as the panel decision is in contradiction to both plain language and clear legislative intent and creates a circuit split on exceptional question of law, this court should rehear this case en banc. That is I don't need to even add anything to that, right? Again, I am not a lawyer. These folks can certainly plead the case much better than I can, right? And so can the senators and their brief. They can much better make the case. I'm just here to commentate on the news, right? Like I always tell you, I'm not an investigative journalist for the most part. I'll chase down leads, of course, and I'll follow up with sources, but that's the realm of people like Whitney Webb. What we do here is we commentate on the news and we curate it. But I really have nothing to add to a blistering brief like that. There's certainly nothing I can add. Of course, as Mrs. Wild's attorney, along with my friend Brad Edwards, I hope that these briefs attract the attention of the 11th Circuit and lead it to grant rehearing en banc in this very important crime victims' rights case. So if you follow Bradley Edwards, you know that Paul Cassell works with Bradley Edwards, and they are, they do a lot of this work together, and they're both very honorable men and very good lawyers. To tell you the truth, if I ever had an issue and I was in their jurisdiction, they would not be people I would pass up in the phone book. Honestly, the way they've approached this case has been pretty heroic, and I've said it time and time again, Bradley Edwards praise should be rained down upon him for the hard work and dedication he has shown in this case. But it's nice to see that the people who actually wrote these laws, how many times have I asked for this? I mean, so I'm getting a little something that I want. We're getting something that we want here. The people that actually put these laws on the books are coming out and telling the corrupt-ass court system that they're wrong. That's not what the law is meant for. Don't play around with the words. And we see it from judges all the time. They interpret things the way they want to interpret it. It's not an opinion game. The law is the law. And I hate seeing judges like these two that really just completely disregarded everything that Courtney Wild has been through, everything that the survivors have been through, and all of the evidence that's available. I don't know. If I was one of those judges, I would have, the dissent, the 60-page dissent that Judge Hull wrote after the decision, that's the kind of paper I would write after making a decision that would lambaste these people. Because the federal government should be held to a higher standard, folks. They aren't, and we know that it's not the case, right? And I know that's a pie in the sky kind of dream for me. But they should be held to a higher standard. They should not conduct themselves the way they conduct themselves on a regular basis. They shouldn't be going into courtrooms and lying to try and get convictions. I don't care if it's against your political rivals or whoever. It should not occur ever. The two-tier justice system is an absolute joke, and it needs to be shattered. And amicus briefs such as this are a good starting point, in my opinion, when it comes to this decision at the very least. We'll worry about this decision here, getting this decision smashed into a million pieces, and then we'll focus on the justice system as a whole. How does that sound? All right, everybody, if you'd like to contact me, you can do that at bobbycapucci@protonmail.com. That's BOBBYCAPUCCI at protonmail.com. You can also find me on Twitter at BOBBY_CAPUCCI. All right, everybody, I hope you all have a fantastic evening, and I will be back tomorrow with the morning update. It'll be a little bit later than usual. I'm going out climbing and hiking at about 5:30 in the morning. So when I get home, I'll drop the morning update. So it'll be a little bit later than usual, but regular scheduled time for the daily drop. All right, folks, until then, I hope you all have a great night.